Okay. Good morning and welcome everyone. I'm Zanae Dames, the Marketing Events Manager at Digital. I'm pleased to welcome you to another one of our insightful webinars, Designing for Impact, How Industrial Designs Can Support Improved Commercialization Outcomes. As myself and much of the digital team are based in Vancouver, British Columbia, we respectfully acknowledge that we are gathered here on the traditional ancestral territory of the Musqueam, Squamish and Tsleil-Waututh peoples. Please note that this webinar is being recorded and will be shared with our audiences in the coming week. If at any point during the session you have a question, please type it into the chat and we'll address them at the end during the Q&A portion. That's it from me, and I'll be handing it over to Jen, our Director of Intellectual Property, to get this webinar started. Thanks, Jen.
Great. Thanks so much, Sine. Bonjour, everyone, and welcome. It's wonderful to have attendees joining in from across the country for this month's webinar. Whether you're new or a returning participant to Digital's IP series, we're thrilled that you can join in for this Thought Leadership Power Hour. Next slide, please. Industrial designs are a cornerstone in the innovation landscape, playing a pivotal role in shaping product differentiation, brand identity, and market competitiveness. However, their significance is often overshadowed by patents, which can lead to a misconception of their value and their utility. Over these next 60 minutes, we'll walk through fundamentals of industrial design protection, the intersectionality with other IP rights, and best practices and organizational lessons learned, integrating and leveraging design protection, and a Q&A portion to close us out. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through numerous vehicles, and informational sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing today's panel. Please join me in welcoming Madeline Hodgson and Charles Levine. Madeline is a senior associate in Norton Rose Fulbright's Intellectual Property Group, where she assists clients with creating, managing, and enforcing IP assets both in Canada and around the world. An experienced prosecutor in trademark and industrial design applications, she works with clients in IP licensing and assignments, development and collaboration matters, and has been recognized by Best Lawyers One to Watch in Canada for her accomplishments in the field. And we have Charles, President and CEO of Lamazoo Interactive, a leader in spatial business intelligence, developing an industrial metaverse enablement platform where big data, IoT, AI analysis, digital twinning, and XR visualization come together, helping companies in sectors that include mining, aviation, oil and gas, forestry, and beyond, helping them make high-quality decisions faster. A technologist, patent inventor, product designer, developer, and speaker, he has been leading teams through concept development to live operations for over 20 years. We're in for a delightful dialogue today. And now let's turn over to our panel. So Madeline, I'll first start off with you. Can you walk us through what an industrial design is?
Hi, Jen. Thank you for the introduction and happy to answer. I'm just going to share my screen because I have some slides that might help illustrate some of these concepts for our audience. So industrial designs are a type of intellectual property protection. In Canada, they're called industrial designs. In the US, they're called design patents. And in the EU, community designs. And what they protect are the unique visual features of a product, essentially the aesthetic. You can see in some of these examples here, it protects the shape, configuration, pattern, and ornament. So for example, a chair, or a graphical user interface, the tread on a shoe, or the flower design on a piece of cutlery. The limitations to protection is the design must be original in the sense that it has to be substantially different from the prior art and not merely a simple variation. A design cannot consist of features that are solely dictated by utilitarian function or a method or principle of manufacture. A design can have a function, for example, a chair or a pair of pants or the tread on a pair of shoes, but it can't be solely a utilitarian function. In terms of time, designs last for 15 years in Canada, initial 5 years, and then renewal periods, 14 years in the US, and 25 years in the European Union with renewals. And another limitation on protection is by geography, like patents, copyright, and trademarks. You need to acquire rights in each jurisdiction where you want to enforce protection. So if you have a right in Canada, you may not be able to enforce it against an infringer in the US. You need to also acquire the rights there.
Thank you for that, Madeline. And sort of, taking it a step further, sort of, as you sort of level set here, can you kind of go through some of the process in terms of how one goes about acquiring this protection, and also kind of more broadly, what do these rights, get you when you do go through this?
So like a patent, you need to apply for an industrial design registration. In Canada, the rights are governed by what's called the Industrial Design Act. And you can apply in Canada, and you can also apply in multiple jurisdictions at once around the world using the Hague Convention. And like patents, a design can't have been published by you more than a year before the application. So if you've got a design in the works, don't disclose it publicly before you file the application. As part of the filing, you need drawings and a description, and the drawings are the key. You can see some examples in the slide up on the screen. The drawings are what set out what is protected. So solid lines in a drawing indicate the scope of what's protected, and dashed lines indicate what is disclaimed. And so if you're filing an industrial design application, we recommend that you include all 6 isometric views and explanations, and make sure that the different views correspond to one another. If you create a 3D model of the product, that's the best way to do it. And you can use line drawings to create a shaded look. And another thing about filing, so the author is the first owner unless the author is an employee who created in the normal course of their employment, in which case the employer is the first author. So another thing to think about is who owns the industrial design, and make sure you have your rights in place. After filing, the industrial design goes through an examination process. It's reviewed for originality. The examiner will look at existing prior art and existing designs. And it is usually approved pretty quickly. In Canada, we rarely see substantive objections. It's typically formalities, and also it's quite a bit cheaper than a lot of different other design protections. Other intellectual property protections. So it's quite a bit cheaper than patents. It's more along the lines of a trademark application in the range of about $5,000. If it's ultimately rejected, there is an appeal process to the Patent Appeal Board. And then once you have your design, it's similar to other IP rights. You can transfer it, you can license it. The design is a negative right. You have the right to stop other people from using it. You may not necessarily have the right to use it if it infringes someone else's existing rights. And if you're looking to enforce it, you have to look to whether their product is substantially different from yours, and it's assessed from the viewpoint of the average consumer, rather than someone skilled in that art.
Thank you. And as you're doing this, do you sort of see the differentiation sort of between the rights sort of per region? So one would have to sort of really sort of think about where they're filing and how they go about that, sort of as a follow-on to that.
Yeah, similar to patents, it's a strategic decision. So you want to typically protect where you do business, where your customers are, and also where your suppliers are as well, because it can provide some protection if you have outsourced manufacturing. So And sometimes we recommend you look at where your competitors are filing as well, because perhaps you'll notice an untapped market. If you see your competitors all are filing in, say, Brazil, it might be a market for your product that you haven't even considered.
Perfect, thanks. Charles, we'll go to you now. Llama Zoo has been strengthening its IP building activities, and as part of this, undertaken the exercise of working with IP professionals on IP strategy. Wondering if you can speak, to that process, and how have these supports sort of benefited your organization?
Yeah, certainly. So in terms of the process, for us, it really comes down to having put together an IP strategy, and that typically starts by, once we do the engagement with the IP professional or professionals, sometimes it's a team, if they want to do a review or an audit of what we do have, from everything from design documents to, sometimes looking at our code base, and that process, depending on how long you've been in business, can really inform the length of the process. If you've only been in business for 2 years, your IP depth probably isn't as great. But if you've been around for 7, 8, or 9 years and you've never done this, it's going to take could take several months to go through that process. And then from there, identifying gaps. Are we missing copyrights or trademarks, or what industrial designs have we filed or have we not filed? What could be an industrial design that is unique, etc. And then even going so far as looking at customer contracts, employee contracts, making sure all of these things are properly defined in terms of ownership and protection against the IP, and even employee contracts. And then, as part of the broader strategy, defining the most likely intended jurisdictions of operation. Where do we need to file? Is it Canada and US? Is it the UK, Australia? Is it globally? Globally would be pretty cost prohibitive unless you're a very big company, because you have to file in pretty much every country almost. There are some exceptions, like Madeline said, the Hague Convention and a few others, but it can be expensive. So being very specific of where to file is a decision that needs to be made. And then in terms of the benefits for me as a CEO, it's really internally, it's kind of like going through a spring cleaning, going through that process, having everything properly defined and organized, knowing where our gaps are, updating our due diligence room accordingly so that we have all these filed documents and or intended filings, so that investors and stakeholders can see that. Creating the deck slide that encompasses or represents what our IP strategy is. That's very important as part of the appendices when talking with investors and even with customers, right? Your IP can bolster your competitiveness and your attractiveness of customers. And it's I think it's an important process to go through, and it can be time consuming depending on when you start executing. And I'll talk a bit more about that in a bit. In terms of how industrial designs fit in strategically, I'll bat that back to Madeline, and she can speak more specifically to that.
Thanks, Charles. I really like to hear that you've had good experiences working with IP professionals, and I think all those things that you talk about are exactly what you should be looking for in terms of building out an IP strategy. An industrial design is part of one element of an effective IP strategy. It's one of the tools in your toolbox to protect your product from being copied by competitors, especially products that have unique visual features. It protects the creativity as well as the decision-making in terms of what the product looks like and how it appeals to customers. So in terms of other IP protection, copyright it fits in with other IP protection, and there's some overlap, but it covers things that are not necessarily copied or covered by other forms of IP, for example. So copyright covers the appearance of something, but if it's a useful article and produced more than 50 times, that it's not protected. Patents only protect an invention, something that's new and useful and non-obvious. It doesn't cover just something that's visually appealing. And a trademark covers a brand, but not necessarily a physical thing and how it works together. So it fits in with other IP protection and complements it. And for example, something that's patentable may also be the subject of a design. You can have something that's got an invention that's part of it. And I think on the slide, there's the Dyson vacuum that you've got. There's parts of it that are covered by patent, but also the look and feel of it, how it appears is something that would be covered by design. And for example, a trademark as well, a design, if you register it, it can become a trademark over the time that you use it. And so rights can transition that way as well. And it's one of the perhaps underutilized forms of IP protection. There's fewer filings in terms of pure filings for protection of industrial designs than there are for trademarks and patents, but it does protect part of something it's part of your product, and it can help prevent knockoffs and copying by your competitors. And I think back to you, Charles,
Thanks, Madeline. What I'm hearing also too is, as we talk about sort of this intersectionality sort of, with these rights, and I think sort of this layering sort of approach, for organizations sort of to think through, as they approach it. So Charles, I'll put this to you, and then Madeline also kind of, jump into this. When should a company, start thinking about IP? In your case, can you sort of discuss, how industrial design fits in, and also sort of from your lens, sort of, as a small and medium-sized sort of org, as you're getting started, what that journey looks like?
Certainly. There's a balance that needs to be struck. You want to be thinking about it early, but not so early that it becomes an impediment to executing on your core product and services. It can form part of your strategy, but you still need to be nimble enough to change course and, redesign and try new things, right? So for us, we didn't really focus on an industrial design protection early on, because we knew that the product design was going to be changing considerably, especially as we're getting market feedback and customer feedback, and iterating, which is really key to kind of finding a product market fit. But once you kind of are in that market and you've commercialized, or you're commercializing and you're hitting your kind of stride, that's probably when you want to start going through the process of protecting things and whatnot. For Lamazoo, more broadly speaking, we always kind of from the get-go started like doing IP protection at the contract level. So with employee contracts, founder contracts, and customer contracts. And I don't know how unique this is, but our strategy evolved in that, we had an initial product, we pivoted into services, but we knew that the services were going to be feeding our IP portfolio as we built up this platform. And so that informed our approach to providing services to clients. And what I mean by that is that when you're typically providing services, you don't own the IP, right? Your customers are contracting you to develop something, or like a website, let's say, as an example. You don't own the IP to the website or the designs of the website unless you explicitly spell that out. And usually there's a cost reduction or some kind of consideration that's given for that. And that was the strategy that we took at Lamazoo, is that we own all the IP. because we're building this kind of war chest of IP that is going to be building up our platform and the use cases of our platform. So that informed our pricing, and our go-to-market with clients in terms of services. And then coming out of that, as we pivoted back into product and SaaS, that's where we started formalizing a lot of the IP and IP protection and putting together our IP strategy. And it's a process. We're still doing it. We're not done. So long-winded answer, but really the gist is it depends. If you're very, product centric focus, like single core product, that's probably something you want to be doing fairly early on. But if you're kind of evolving with the market and you're experimenting and testing things, you want to leave some room to kind of not have to go and redo all of your IP filings, because that could be quite time consuming and expensive.
I like Charles's point that you made that contracts are important, especially that you are making sure right from the beginning, in fact, that you own the IP, or at least you're clear about where IP is going to lie. So with employees, contractors, suppliers, that you make sure that IP is at least addressed in those contracts. And I think that's a good point. Even if you're just starting out, the first place you should start thinking about IP is right at the beginning, and that goes with just development, and contracts are the first thing. And then the other point I wanted to make is that confidentiality is also key, especially if you're thinking about protecting something in terms of a patent or a design filing. You want to make sure that you've got the confidentiality provisions in your agreements to make sure that nothing is disclosed and you're not going to be putting an eventual filing at risk with those contracts. So I like Charles's point, and I agree. Contracts are important.
Thank you both. And yeah, sort of as you both have sort of shared on this, that it's also a very iterative sort of, an evolving sort of process. Charles, as you've kind of indicated, you're constantly in motion, sort of thinking about this. And I think for the organizations that are, joining us today, and those out there, to kind of know that it's not a, one size fits all, or sort of a one and done, that it is as your business evolves, as your models evolve, sort of as you sort of pivot, it's to sort of hear as you've been sort of adjusting sort of to that. Madeline, I guess to add a little bit to that is, where are you seeing sort of, when companies are starting to think about their IP, how early on are you seeing that in that evolution?
So I'm seeing companies look to protect designs perhaps later than they consider patents and trademarks. And I think that's partly because, as Charles was saying, sometimes your product is changing and you're modifying it to go with the flow. You're modifying it in accordance with customer feedback and manufacturing processes. So you may not have the design that you want to protect right at the beginning. But one thing I'd suggest is that you keep it in mind from the beginning, because possibly a product you sell now, if you decide to file an industrial design protection for it later, the earlier sale could prevent you from getting that design protection later. So it's something to consider right from the beginning. And industrial design, it can evolve in the same way a patent can. You can file one version, and then an iteration can be a second version, a child patent, if you will, from the first filing. And so some ways that I see companies successfully protecting it, and the example that I'm up here is the Apple and Samsung case. And many people don't know this, at least I remember in law school when I heard about this case, and I'd have friends.
Can you share your slide again? Because we can't see it.
Pardon, Jen?
We can't see your slide if you've got something up.
Oh, sorry.
Yeah, that's okay.
There we go.
Perfect. Thank you.
This slide is just an example of some of the enforcement cases that I've seen The Apple and Samsung case is something that was going on when I was in law school, and friends who weren't in law school were asking me, how can Apple have a patent for the shape of an iPhone? And I have to explain, it's not a patent, it's a design, it's a different concept. They have protection for the aesthetic visual features. And so people hear about this case and they think that Apple had a patent for the shape of the iPhone, but no, it was design patents mostly. The case between Apple and Samsung was mostly about design patents. And Apple successfully got infringement declarations with respect to Samsung's designs. You can see the references to the designs. The D means the design. And I think the jury award was more than $1 billion. I think that was later reduced, or it was settled for an undisclosed amount. But that's one example, a big example of where designs have been successfully used to protect your market share and protect competitors from designing similar products. And a Canadian example is the Crocs case. You can see an example of the Crocs design for their fleece-lined shoe, and then there was an infringer that had a very similar product, not identical. It might be hard to see in this picture, but the holes in the foot were not the same. Similar, but not the same. But it was substantially similar. The court found it was substantially similar, and it was infringed. And of course, that can lead to damages for the infringement. And so that's another example of a successful use. You obtain your industrial design and you use it to stop knockoffs in the market. And one other case, it's a little bit more, it's older and it's more of a classic example. And it's an example of something I was talking about earlier, where you have a design protection that can turn into a trademark. So the Coca-Cola bottle, the classic curved shape of the Coca-Cola bottle, it was initially an industrial design. And over time, while it was still an industrial design, you use it, you gain reputation in it, and that can be used later to file for trademark protection on the basis that you've acquired a reputation in this packaging that then entitles you to trademark protection, which is ongoing. It doesn't run out the way a design protection does. So that's another example of successful use of industrial designs.
Thank you for that, Madeline. I'm also wondering if you're able sort of, to share examples. I mean, these are great and they're, sort of large sort of scale, organizations, but, so some of the things that you're sort of seeing, in daily practice from, say, some of the smaller organizations, the startups, the SMEs, that maybe don't have sort of this breadth of, prowess, from dollars and sort of legal and other sort of things to be able to do this, where companies are successfully and strategically utilizing this, across maybe, say, different industries, or you talked about sort of from some of the software side of things, which a lot of organizations, are doing these days. Maybe if you could share some of that with us.
Of course, I'm not going to disclose any confidential information so that or any privileged information.
No, of course not. But just something to share, like in terms of So it's similar. And while these are the big examples, these are the ones that make the news. It doesn't take away from the inherent use of a design protection, filing for the shape of a product, the appearance of something that allows you to stop competitors from copying it. And I've seen it successfully utilized by smaller companies, by SMEs that are just starting out. It's the idea that it's a type of IP protection. It's a type that can be enforced. It's not overly expensive to obtain or maintain, and it's usually much easier to get than a patent and much cheaper. So it's one of the things that I see as, even for startups, that while these examples might be for larger companies, it doesn't mean that there aren't examples of smaller companies successfully enforcing their IP. It's that often these cases don't
make it all the way to a trial decision. And in the ideal case, you send out a demand letter and your competitor stops using the same design. They have to do a redesign. And that's typically what I see, because the force of a registered design is often enough to stop competitors from infringing your product.
Thank you for that. As we talk about sort of examples, successfully and strategically sort of utilizing this, are there any instances sort of that come to mind, of pitfalls or sort of, considerations that organizations, sort of should be mindful of, or where it didn't quite go sort of as planned, and what that looks like?
Well, the classic thing is making sure that you're not copying someone else's design. And so if you're designing a new product yourself, it's prudent to do a design search, but also in any agreements with, for example, you've hired someone to create a prototype, make sure that there are some representations in place in your agreement that says they're not going to copy someone else's design. And that's helpful, because if you've hired someone to do something and they've taken someone else's design, you might ultimately be the one liable for infringement if you start selling a product that is an infringement. And so again, that comes back to what Charles was saying about contracts. Make sure you've got those IP provisions in place. And also make sure that you're not just looking to see what else is out there and copying a successful design, because it might be subject to protection.
Also, if I may add, customer feedback and input can be construed as like design. And so it's important to also have that in your customer contracts that stipulates, any feedback or any information provided to the company, to us, becomes part of, our IP and knowledge and design, if we so choose to use it. So that a customer can't then further, in the future claim like, oh, but we provided that feedback, you made that change, that's ours, that kind of thing. So, yeah.
Yeah, that's a good point. I've never seen it happen directly from a customer, although it perhaps depends on the industry. I think maybe if you have fewer customers, they have a little bit more clout, and they can identify more easily what was their contribution to your product. But I have definitely seen those type of claims from contractors or prototype designers where they've contributed to something and there weren't IP protections or assignments in place.
The many moving parts, right? And sort of, not only sort of is it iterative sort of in where sort of the IP strategy fits in your business, but also ensuring that the right conversations are happening and sort of those and understanding what's happening sort of in your business. Charles, I'm going to kind of take it back to you now when, thinking about where IP fits into Lamazoo's story and some of the things that we've spoken about today. What is your sort of plan in sort of managing your strategy, your filings moving forward, and supporting, your improved commercialization sort of outcomes and what that story looks like for Lamazoo?
Yeah, I mean, for us, I'd say we're kind of entering the second or third inning of IP, strategy execution. We have our roadmap, we know where the gaps are, we know strategically where and what we should be going after in terms of protection. And I think over the next 12 months, maybe less, I'd say probably like 6 to 8 months, it's really like what we want to do is do a deeper dive in our existing IP and do like IP harvesting, right? So defining a bunch of patents, extracting a bunch of design protections, industrial designs that may not have been obvious upfront. And again, as Madeline was saying, it depends on like, public disclosure, public like release, right? The statute of like protection is 1 year. So we also have new products that are coming out this year, in particular with the Apple Vision Pro, that we want to kind of protect a lot of the designs there. And so, yeah, it's really, this year is going to be kind of bolstering our IP portfolio for a lot of the kind of interesting conversations that we're starting to have from investors and M&A parties. And this is important to have because IP protection is a very tangible, I don't know, a rune or artifact that, when talking about valuation and, you know, a transaction, you know, yes, revenue and EBITDA are often the main thing, but if you have an IP portfolio that is well defined, it can definitely help sway the conversation.
Yeah, it definitely sounds, I mean, in your case, and the organizations, you know, that are listening in, sort of that pivotal role that places, and really sort of, you know, having that understanding. Is there something, you know, that has sort of surprised you along the way as you've been sort of on these journey, or sort of an aha moment as you've been on your IP sort of roadmap and sort of strategy build?
Well, I guess understanding the landscape better, like what is kind of protectable, like industrial designs, and versus, you know, copyrights and trademarks and patents and inventions and you know, like trade secrets, even, right? Like trade secrets to a degree are protectable by not disclosing them, right? It's a very interesting kind of realm, and it's one that the more you know, the more you can inform and influence your strategy. And so working with the right professionals and you know, partners up front can really help inform that, unless you already know that landscape. But yeah, for me, it's, you know, navigating those landmines and better understanding what's possible and what's beneficial, and forming a strategy from that.
And something, you know, I wanted to just also ask you too. I mean, as we kind of did in your bio, you know, as sort of, you have a patent inventor side as well, sort of, to you. And oftentimes, you know, as we talk about today, is that there's a lot of thought around patents. But do you find sort of, you know, having that lens, has that, you know, sort of helped you as you've been sort of thinking and devising sort of the strategy around sort of the industrial design? And if somebody sort of didn't have that, you know, how would that journey kind of look for them? Did, you know, kind of confidently to sort of walk into that? Is that also, can it be a hindrance if you don't, if someone's thinking, which way would I go?
I don't, so for me, it kind of started in my prior career, like working at Microsoft. It was always kind of top of mind, but they also tell you, like, don't research anything that is existing patents, because that can influence the patentability of things. So it's kind of like, be aware of it, but don't dig into it, right? Like, you don't know what you don't know. And so I think for me, for Lamazoo, is probably more influenced by our academic collaborations, you know, universities, and more like collaboration organizations like Supercluster, right? So coming out of our Supercluster project, there were a number of new inventions and designs and IP you know, artifacts that were created. And so we went through the process of defining those, and that's when we kind of started thinking more and more about, like, okay, well, we should be looking at filing patents and you know, industrial designs and that kind of stuff. So yeah, I mean, I think to directly answer your question, I'd say no, it didn't really influence, but it's certainly something that I'm more and more interested in. And, you know, over the last 24, 36 months, as we've been working more and more in that kind of space, it's, you know, I've been learning a lot more about it, and it's something that I'm interested in kind of pursuing more in terms of, you know, doing our IP harvesting and furthering our IP strategy.
Perfect. Thanks, Madeline. If there's anything else you wanted to jump in on that, otherwise I also have another question for you as well.
Sure, go ahead.
Are you sort of, seeing sort of where you're currently sitting, emerging trends or developments that, are impacting or, down the line, could impact, industrial design protection, whether that's in sort of certain industries or sectors that you might be seeing?
Well, probably the biggest trend we've been seeing is that there's an increasing number of industrial design filings relating to software, graphical user interfaces specifically, that protection is emerging as one of the biggest categories of industrial design protection. And it's rightfully so. It's one of the areas that has grown in the past decade or two as an area that's becoming more and more important in the industry, in the IP landscape generally. And so it's one of those filings that increasingly we're seeing it be more important and make up a bigger proportion of the industrial design filings.
And sort of based on what you're sort of seeing there, I guess the thought is sort of to engage in discussions early, and really kind of have those resources and those IP professionals that you can sort of walk through to ensure that you don't fall into one of the pitfalls sort of that you described earlier on.
Yes, exactly. Engage IP professionals early. And if that's not in the cards for you yet, make sure you understand that there are different types of IP, and designs are one of them. And so think about IP ownership and licensing when you're engaging with your contractors and employees and suppliers and customers, as Charles mentioned. Just have that in the back of your mind. Think about IP and where it lies, and make sure confidentiality is top of mind as well, because that can affect your protection later on.
Perfect.
Yeah,
and
and
Charles,
I
was going to say, if there's something you can add in too, it'll be great.
Yeah, sure. I mean, there's a cost associated to working with professionals, of course, right? And then as a startup or a small company, you might be more cost sensitive, but there's actually one of the trends I've noticed in the last, I don't know, few years is that there are more and more programs across Canada to support companies to work with IP strategists and professionals. So, NRC IRAP has the IP strategy program. There's the Accelerate IP through ISED, which in BC is managed by New Ventures BC, right? And so this is like direct funding, project level funding that's available for companies to start working on an IP strategy and actually fund some of the filing costs and legal fees and that kind of stuff. So do make use of those, because in Canada we need to be doing more of it. We need to be protecting our creations and our inventions and our IP, because it does create a competitive edge, and it's important that we make use of that, and that's why these programs are being created.
Thank you for mentioning that, Charles. That's a very important point. I of course have seen that too, and see that clients are successfully obtaining some funding to help them do an IP portfolio and even file for protection. And so even for smaller startups, that advice can be available earlier.
Yeah, thank you for sharing that. That was going to be one of the questions in terms of resources. And I think, the importance of, IP in dialogue, for organizations, and, what that means, on a individual sort of, competitive level, but also for our country, and sort of globally, sort of where we sort of sit. So it's great to see, these different programs and, others as well that we have through, IAC and IPON and other organizations that are part of the ecosystem. So definitely encourage everyone, who's listening in, to look at these and to take advantage of them where and as available. A couple of things to kind of want to flesh out as well is around maybe Madeline, if you can talk to us a little bit about that, and maybe, Charles, you touch a little bit around some of these things. These things can cost, in sort of in dollars, sort of in time. Could you share with us a little bit around sort of industrial design, sort of registration fees and timelines? I know there's one thing that's come in through the chat that also had a link to filing an industrial design registration in Canada. So maybe Madeline, if you can share that, and Charles, sort of from your, organizational side, what that's sort of meant for you guys.
So in terms of cost and time, filing an industrial design is typically both cheaper and faster than a patent. It's more along the same lines as a trademark application. So in the thousands of dollars, but not the tens of thousands of dollars in Canada, at least. It depends, of course, on the jurisdiction. And as Charles mentioned, if you want to file in every jurisdiction in the world, it would be expensive. There are some cost savings if you use the Hague Convention for filing in multiple jurisdictions at once, but it can get expensive the way any IP protection by jurisdiction can get expensive. But timing is also important, and you can get faster protection, at least in many places, for a design than you can a patent. Sorry, Jen, I may not have answered all of your question. I may have just focused on the cost and time.
Oh, you're muted.
I'm muted. And Charles, like sort of from an organizational standpoint too, you're sort of seeing, to be mindful, right, of those costs and time that it takes.
Yeah, I mean, it's not so much the filing fees. Like, the filing fees are, I'd say, almost negligible compared to the actual process and the time that may be required. And that time will be predicated or influenced by like your awareness in the process, right? Ahead of doing the filing or the harvesting or the definition, right? So if you have somebody, or if you create that awareness, in your team, your design and developers, you say, hey, anything unique or that you think is like quite novel, right? Like, let's just put a flag on it so that we can come back to it, know that it exists, why it's unique, right? So documenting those kinds of things then makes it a lot easier, so that when you're working with the IP professionals, you could be like, hey, here are the 13 things that we think are unique or novel, right? And then they can then assess and do a background check and, do all that process a lot faster, in my experience.
That's great. You've kind of hit into sort of another part that I was going to ask, is really around, how companies sort of can do the legwork, right, around sort of industrial design, sort of registration, sort of one, from minimizing costs, but also, sort of strategically. Madeline, is there anything you'd like to add into that from when they're coming to you?
Well, the more company can do themselves, the more they're going to be saving cost in terms of IP professional time. The filing fees, like Charles mentioned, are negligible. It's the preparation of the application, and for an industrial design, that's the drawings. And typically, an IP professional won't create the drawings themselves, but they can provide some advice around what drawings are needed. So if you have an idea going even before you approach an IP professional, that this is something, this is unique, this is something that we think is different and from our competitors, and something that we think is going to be a success. Having those ideas just around what IP protection is available, and creating the background, the support for it before you even talk to an IP professional can help. So the drawings and just to discuss with them, this is how we came up with it, this is why we think it's unique, will help save you time.
And just a little bit further from sort of what you've just sort of added in terms of, how they are, unique and what an organization should sort of think of. How does one make sure, or, sort of, are there any sort of tips around dealing with designs in a way that people can't easily work around them? I think that sometimes can be a concern sort of organizations. Are there things that you've seen in practice that, has worked well and less so?
Well, working well, sometimes that will involve filing multiple iterations of a design. So you have one protection and then you file another version of it, essentially, that protects a variation. And really what you're trying to protect is the thing that's unique about the design, but also the thing that you think is going to be copied by someone else. The unique look, the unique feel, the unique feature, and it may not be patentable, because then of course you might be looking to patents, but it's the thing that helps distinguish you from others. And I think if you go back to the Apple and Samsung idea, it's like the rounded edges, which was unique. And you don't necessarily need to have all the different variations protected. What it is you're trying to stop a competitor from using something that's substantially the same. So taking the substantially the same design, there may be some slight variations, but that doesn't mean that it isn't substantially the same. And that comes down to how different it is from what other people have done before, and what the competitor tries to do to get around it, unfortunately.
Thank you for that. And Charles, from an organizational sort of, lens, are there things sort of, that an organization should be mindful of, as they're dealing with that internally, and things that, you've also sort of, seen that, have worked?
In terms of avoiding infringement, or?
And sort of how to look at it so that people aren't so able to easily sort of work around them, or are there sort of practices as an organization thinks about this, are there things they should think about in terms of best practices?
It's tough to say. I mean, I think it comes down to, like, design is a fairly intimate process, if you will, and you don't want to deviate too far from the norm and cause your users and customers to have to learn something entirely new, right? So you want to borrow from best practices, and I think many things out there are in kind of the open domain, right? Like in terms of GUI design practices and that kind of stuff, but you also want to create something unique enough that is easy to use and novel, that it will delight your customers, right? So it's kind of, there's always this like yin and yang, this push and pull with design. So I mean, I wouldn't say try to design something so unique that it's protectable and it's going to be the marquee of your product, right? It's more important to create a great product that is going to be usable and delight your customers, right? That should be the number one. And then if it happens that you have something that is, protectable or that is defendable, then go and pursue that. That's my opinion.
Thank you for that. No, thank you for sharing that. Helpful sort of to have that lens as well. As we wait for sort of some questions to come in, I just wanted to also put out to you both: are there any sort of other additional resources that you'd recommend to stay current? So I know, Charles, you talked about some of the programs that are out there. Madeline, are there also sort of other resources non-program wise that come to mind? And same goes for you, Charles, for folks to stay current.
Well, for staying current, and just for conducting your own due diligence, doing searches, there's the Canadian Intellectual Property Office provides plenty of information, guidance, and search tools for industrial designs, as well as patents, copyright, trademark, as does the World Intellectual Property Office. So the search functions can help an organization if they're looking for what do our competitors have in the way of designs? What should we be looking at to protect? It can help give even a small company an idea of what the landscape is for their product. And so that's a good tool just for learning and also for doing some searching.
Perfect. Thank you. There's a question that sort of has come in sort of on that thread in terms of, how one can monitor, for an infringement of their ID, and also, how one can enforce their registration. I know you touched a little bit upon that, Madeline, earlier on.
So enforcement, like other forms of IP, is jurisdiction by jurisdiction. So if you notice that there's a company that has a product that's the same as your registered design, but they're only selling their product in some other country where you don't have protection, it's going to be difficult for you to stop them. And in fact, probably impossible. So as a starting point, make sure you have protection in places that you think you might be looking to enforce, where your competitors are, where your customers are. And second, I think I lost my train of thought there. So seek protection where you want to enforce is my first recommendation.
Yeah, and I guess on that point, it's like keep an eye on your competitors and your product category, right? And be in the know of what's happening, right? And that's probably where you'll find any infringement, any most likely meaningful infringement, right? If it's an entirely different product category, but they're kind of borrowing or using some of your design cues or elements, like, is it competitively going to challenge you? Maybe not. And so enforcing that, maybe not worthwhile, in my opinion, because enforcement action, costs time and money. But again, that's not legal advice. I'm not a lawyer, so it's up to you to decide. But yeah.
Perfect, thank you. And as we're about to come up for time, what I wanted to, there's one more question has sort of come out, is around processes, and the context and conditions around looking at patenting sort of processes. That might be something that we can save for another day, or just kind of touch upon a little bit, Madeline, as we kind of file out here.
Well, patents for processes would be a utility patent, so an actual patent rather than a design, an industrial design. So different considerations. Processes you'd have to go through the patent process rather than the design process. The designs will protect the visual features, but not the process that someone goes through.
Perfect. Thank you for that. And just wanted to, ask you both sort of, as we end off today, is some takeaways, a key takeaway or key takeaways, to leave the audience with as they sort of, make these considerations and think about embarking on this journey for their org. Charles, I'll put it to you first. What would be your takeaways?
I mean, my key takeaway is, don't be afraid of this. I think it's another tool in our toolbox as founders, operators, and business owners. And, it's one of the many tools, but, there's help out there, there's funding. And, the earlier you start on the process in the journey, the more comfortable you'll be with it, and the more you'll understand, and the more you'll be able to use that tool strategically.
Yeah, I like that point. The earlier you start, the better. Doesn't necessarily mean that you start with a filing, but being aware of it and keeping it in mind as you build your business is something that's important.
Wonderful. Thank you both so much. And before I hand it off to Zane, on behalf of everybody sort of in the room with us today, a huge thank you for carving out time out of your days, to share these insights with us, and look forward to continuing the conversation. So with that, Zane, I hand it back to you.
Thanks, Jane. Thank you once again for joining the webinar today, hosted by Digital and our wonderful director of IP, Jane. The recording of this webinar will be available on our YouTube channel and website, and all those attending today will receive a follow-up email in the next couple of days with any resources discussed throughout the session.